So, welcome to the Casual Energy Podcast for April 2021. I'm Jason Gravel, and of course, our co-host Fred Fernandez is with us. And joining us today is soon-to-be Dr. Benjamin Ralston. If you can say that, but who knows how long it actually takes to do a PhD. But, so why don't you go ahead and introduce yourself and tell us a bit about what you do.
Sure. My name's Ben. I teach at the University of Saskatchewan College of Law, and I'm doing a PhD here in law as well. So among other things, I teach environmental law here at the University of Saskatchewan, and I'm working on a PhD that has to do with environmental impact assessments. How's that?
Yeah, sounds good. So the big thing that we want to talk about today is the recent Supreme Court of Canada decision that ruled that the federal government's carbon pricing legislation is constitutional. And I mean, I guess this would be within your area of expertise, eh?
Yeah, sure. I wouldn't call myself an expert in carbon pricing from a policy perspective, but it's a case about federalism, and I'm very familiar with how environmental law works from a federalism perspective in Canada.
That sounds like a very lawyerly response.
That's what I'm here for.
So this is a big deal. So I bet Jason Kennedy, Scott Moe, and Doug Ford are all hiding out in Alberta's war room right now, consoling each other. So I guess, Alberta, Saskatchewan, and Ontario are all all challenged the carbon tax. Was this a decision to all three challenges, or are there still outstanding, any challenges still to be tested?
No, this resolves all three outstanding challenges. So there was one in Saskatchewan. We started this whole thing, I guess. And then after that, Ontario, finally Alberta. All of those have been resolved now.
Interesting. So how does that work? Do they group them all together when they're coming up? Because the challenges at a lower level happen separately, right?
Yeah, so they don't necessarily have to do that, but essentially what you can do is you can apply to have multiple cases heard at the same time at the Supreme Court of Canada, and this was a pretty obvious example of where that would make sense. I guess in theory, they could have resolved the Saskatchewan challenge, and it would have then made the other two moot, but they decided to just hear them all at the same time and resolve them in one fell swoop. And these were all, they're called reference cases, where it's not a lot of factual evidence. It's very abstract, very legal. And so, there isn't a lot of difference between the various cases other than the preferences and views of the courts of appeal in each province, I guess.
Oh, okay. Interesting. So what were the central arguments then against the carbon tax? And you're saying that there weren't a lot of differences between kind of the three different challenges.
Yeah, I guess it depends on the level of detail you want me to go into. But
as detailed as you can.
Yeah, because it can get dry if we start to dig down into it. But I was trying to wrap my mind around how I could put this in layman's terms. The simplest way.
Are you saying we're laymen?
You guys, you're all
raise
laymen.
Hand. Yeah, no, absolutely.
So I think lawyers were the only profession that defines every non-member of the profession as laypersons, right? Just like non-lawyers, heathens. Anyway, so for the layman perspective, here's what I'd say is Canada's a federal country, right? Not all countries have these kind of issues. If we were in France or New Zealand with just a centralized national government, a challenge like this could have never occurred. It was all about the balance of powers between provincial governments and the federal government. And for us, that's set out in the 1867 version of our Constitution. And so there's an original agreement, used to be called the British North America Act. Now we just call it the Constitution Act 1867. And it has two provisions in there that basically list, as at 1867, what our founding fathers felt should be provincial powers as opposed to federal powers for what would have then been a newly created federal government. And lo and behold, in 1867, the environment wasn't really weighing on people's minds. And so we have an 1867 Constitution that doesn't directly speak to environmental protection. And in part, that's because within at least Western law, we weren't really regulating to protect the environment yet. There were environmental protections in terms of property rights. There were a few examples, protecting fisheries, but more from the perspective that it was another form of property right. But we didn't have, species at risk legislation or environmental assessments or anything like that back in the 1800s. And so what we've seen is as our modern era of environmental law came about, which started in about either 1969 or 1970, depending on who you ask, we've had this modern era of lawsuits in Canada challenging federal powers to regulate the environment that come back to this point as to there not being a specific place in the original Constitution where you can say which level of government has the power to regulate the environment. So there are some things that are fairly clear. Navigable waters are set out in the federal powers. And so we've got Navigable Waters Protection Act. There's federal legislation for that. We've got fisheries set out under federal powers. And so we've got a Fisheries Act, a very powerful piece of environmental law at a federal level. But for the most part, natural resource management is provincial in nature under our Constitution. And so you find the majority of environmental laws are province specific. Gets a little messier in the territories. And so in some senses, federal regulation and protection of the environment is the exception rather than the rule under our Constitution. And yet, for a variety of political and other reasons, we have our most powerful legislation for the protection of the environment at the federal level. And, taking a step back, the bigger picture is that the environment does not respect provincial, territorial, or even national boundaries. The nature of the environment is it's about as broad in scope as the globe. And so we've got all these artificial political and legal boundaries within which jurisdictions are exercised by these dueling governments with their own political mandates and ideas. And so we have all these coordination problems, whether it's for climate change, it could be marine pollution, it could be protected areas, protection of freshwater species at risk, etc. Right? And so ultimately this case, if you're to read it cover to cover, it's a long one. It's a very dry read and probably not something that's that interesting to non-lawyers. But for lawyers and law professors, it's a fascinating read, whether or not you're involved in environmental law, because you've got a case that is really revisiting some basic principles about how our country is structured legally in terms of these dueling jurisdictions and bringing it into a very modern lens, because I think if there's any kind of international and national crisis that we're tackling today, it would be climate change. How does that make sense? A decent background for you?
Yeah, does that make sense? How do you feel about that, Fred?
Oh, it sounds informative, that's for sure.
Yeah. So, I mean, from the layman's perspective, I heard that the provincial government's arguments had a little basis in law. I mean, is that true, or is that kind of a stretch?
Yeah, no, I'd say that's a stretch. So from a legal perspective, the province has had valid arguments. Here's what I'd say is that a lot of times we see things happening at a federal or a provincial level, right? Laws are in place, things are going on, and no one's challenging the jurisdiction to do so, right? It's when there's the political will to challenge the jurisdiction, could come from an individual, could come from a government, that these questions make their way before the courts. But for the most part, legislation's in place, the rules of the game are set out by governments, and we dance along as we have to, being the regulated individuals here. And it's up to these court cases to kind of push back and to clarify the nature of federal jurisdiction versus provincial jurisdiction, kind of a classic constitutional fight. And so, here's what I'd say is if the provinces weren't opposed to what the federal government was doing, they didn't need to challenge this, right? So it could have been, everything could have been going ticky-boo with the federal legislation in place. It does give space for provinces and territories to put their own regimes in place as long as they meet national standards. And originally, in 2016, you had all the premiers and the prime minister essentially agree that we needed a national framework for addressing climate change that would include carbon pricing. But then what we saw is politics changed at the provincial level in Alberta and Ontario. And then a few smaller provinces felt maybe they had a bigger voice once there were more conservative premiers in place. And so what started off as maybe an uneasy consensus that there should be a national framework for carbon pricing starts to fall apart, and then these arguments make it to court.
That's sort of something I wanted to ask too. As the Trudeau government was, planning this whole thing, did they not consult the provincial governments? But like you were saying, that because of new governments in place voted in, that sort of changed the dynamic and relationship between the federal and the provincial governments.
Yeah, exactly.
I see.
It did come down to politics. And so, maybe to cut through the noise, because some people, you've probably heard the media saying, this was all bullshit and there was really no legitimate legal arguments being brought.
Right.
I don't think you'll find any lawyers saying that per se. Many people speculated that if the federal government doesn't have the power to step in place and make a national decision on something like climate change, what good is having the country, right? At that point, we're just a couple, sovereign provinces that happen to be contiguous with one another, right next door to each other. But putting the legal piece aside, if it weren't for this particular framework, so if they hadn't created the backstop that allowed for provinces and territories to design their own carbon pricing regime, there were other ways in which the federal government could have regulated greenhouse gas emissions anyways, right? So ironically, the opponents are calling it a carbon tax, and it's not really a tax from a legal
it's
perspective.
Carbon pricing, I guess.
Exactly. Yeah, it's carbon pricing, right? It's revenue neutral. A tax is by definition a way of generating revenue. So it's not really a carbon tax. But what we do know is that the federal government does have a taxation power, right? And so ironically, right, you'll hear this a lot. Oh, it's a cash grab. I mean, it's the exact opposite of a cash grab. It's just like BC's carbon tax, where it's meant to be revenue neutral, not necessarily as part of the policy design, or I guess as part of the policy design to make it politically more acceptable. I don't know how else to describe that, right? So, ultimately, if you're in Alberta or here in Saskatchewan and you're in one of the jurisdictions with a government that's flipped the bird to the federal government on this, we should get roughly what we've put into through this carbon tax back after tax time. So it's not meant to generate income for the federal government. But if they wanted to, they could have done that, right? They could have done an actual cash grab. They do have a constitutional power to impose taxation at a federal level, like the GST, for instance. And how else could you fund a federal government, right?
Yeah, even in areas though that would be traditionally the purview of the provinces. So I mean, like, I guess the reason why I asked that is because, like, to some extent, does this kind of resemble kind of the crisis they had with Trudeau Sr.'s national energy policy? I mean, I don't know enough about that to say, but I guess, on an intuitive level, it does feel very similar, yet and maybe you can explain that a little bit.
Yeah, I'll tease those apart. So, being a former Albertan myself, I know at least that sort of intuitive version of the National Energy Plan.
Yeah.
What we're talking about in the National Energy Plan, or at least the way it's framed, is nationalization of a resource primarily located in Alberta, or located in Alberta in the greatest abundance, and you've got a situation where the provinces own the natural resources within their boundaries. Okay, so let's put that aside, right? That's about who gets the revenue from resource development in each province, right? Here, if this were designed as a true form of taxation, we'd be talking about GST and PST, right? Are we going to harmonize them, or will they overlap? But you've got two levels of government. They're both allowed to tax in order to generate revenue. So there is a taxation power, right? So I don't want to get too into the details as to what that might look like, because that's basically an alternative reality at this point. But it's one of the ways in which the federal government could have imposed a true carbon tax had they wished to do so. The problem is, though, if they had done that, then they wouldn't be allowing provinces like Quebec to do, cap and trade, and BC to keep going with their carbon tax. They wouldn't be allowing for this diversity of different approaches, because you did have some provinces that were leading the way. And I hate to say it, but BC, Ontario as well, Quebec as well, and even Alberta. Alberta has, for a long time, had carbon pricing specific to large industrial emitters. Right?
Really?
We invent this stuff like this is, carbon taxes. It's this big scary monster that's creeping across the sky right now. But we've had ways of dealing with carbon pricing for quite a while now. It's become hyper politicized, and this is just one more way of further politicizing it. And it's one of the reasons why people are saying, some people say, oh, this will be, you'll have Jason Kenney licking his wounds, or, Scott Moe here in Saskatchewan licking their wounds. But it could be they're just going to bang on the piñata that much longer, right? And that the next federal election, it'll be, let's go on more and more about the evil carbon tax that Trudeau imposed, right? So politics work very much independent from the legal system. And it's the lawyer's job to come up with a credible argument to kind of keep that ball in the air and bring it up to the Supreme Court of Canada and make the headlines. But there is a political piece happening at the same time that is somewhat disconnected from the outcomes of these cases.
Would you say, is there any benefit to educating the population regarding this? Does that change anything? Does that politicize it even more?
You know what? I think it's helpful in the sense that at least what we do have is a moment of education around anthropogenic climate change, so human-induced climate change. That was something that the Supreme Court of Canada took judicial notice of, meaning that they didn't need to see evidence at this point that humans are changing the world's climate. Right. It is such an established fact that it's like judges taking notice of the fact that the sky is blue, right? They don't need people bringing evidence into court to reprove that again and again. Right. And so what you do have is now a number of court cases as a result of this very expensive litigation, where courts have said, it's the crisis of our time. Greenhouse gas emissions are this real live thing that we need to deal with. It's a small win, but it's a win.
Right.
But it starts to have this educational function, right, where people are learning more about exactly what this regime is and what it's not, hopefully. But it all depends on the way in which media digests it and then portrays it to people.
I guess it's almost unavoidable for it to be unpoliticized.
Yeah, I don't know. I think it's another thing where it's avoidable. I mean,
avoidable, sure.
Yeah, it's harder because there will be. I mean, the whole point of carbon pricing is to change the behavior of industrial emitters, but also individuals, right? Because it's not just industry that is, producing large amounts of greenhouse gases that are changing our climate. It's also individuals, and so, from a policy perspective, ideally, we're changing all behaviors across the board, and we're not just targeting industry, right? It's actually an inherently conservative approach, right? It's usually the conservative economists who propose something like a carbon tax that is neutral across the economy, because it's not favoring one industry against another.
Right.
Though usually when we see it designed, it does exempt a few politically,
Yeah.
protected industries like agriculture. But ultimately, when you're trying to change people's behavior, people aren't going to like that, right?
Yeah. So
Someone's
that's like
moving my cheese.
that's like BC's model, right? Because then it was kind of hailed, back in 2008 when it was introduced as kind of a global model because it was evenly distributed across consumers and businesses as well. And then it was kind of structured in such a way that it was completely revenue neutral in it returns. And as you say, touching on it, while I know it was the BC Liberals under the Liberal banner that introduced it, but really they're more libertarian than liberal and more on that conservative end, right? Yeah. And so it's interesting how it's kind of positioned as this thing from the left, the scary monster from the left, but it really isn't originally.
No, not at all. And I love the BC example because it gives you an alternative universe where, someone's just on the other side of the aisle and
Yeah.
they're benefiting from making a crisis out of it because it's going to cost people more money, or it's going to cost them more money if they don't change their behavior. And so
Yeah.
if you remember Gordon Campbell, who had been the premier of BC under the BC Liberals, which are essentially the Socreds, they're like the equivalent of a progressive conservative party. And so, it was a right-leaning government that imposed a carbon tax in BC, and the NDP at the time were like, "Wow, this is going to hurt families."
No, exactly, yeah.
That. And they were screaming bloody murder. And even David Suzuki was just like, "What are you saying?" It wasn't a great look for the NDP at the time, right? I mean, anyway, so it's really. And we see the same bizarre thing happening where we've heard federal conservatives suggest that rather than a carbon tax, and I'm putting that in air quotes so you can't see me, because it's not truly a tax, but rather than this price on carbon applying across the board, it sounds like the federal conservatives have been suggesting it would be better to just target the heavy industrial emitters, which is not exclusively Alberta, but it's predominantly it's going to hit hard in Alberta, right?
Yeah.
It's going to hit the oil and gas industry. And so there's not a coherent conservative position against this, right? A conservative free market economist driven model would be this kind of carbon pricing model. And so it's kind of ironic, almost hilarious, right? Because you've got some progressive people who are rallying behind what's a free market model, and then you've got some purportedly free market driven individuals politically, screaming off the roofs or rooftops how terrible this is. The actual politics of it don't line up in a principled way, but it is what it is. Life in the 21st century.
No, totally. So I guess, does this close the carbon tax debate for good, at least short of a future government repealing it, at least from like a constitutional perspective?
Yeah, so here's what I'd say. There is no doubt that provincial governments, like BC has done, can impose a carbon tax, or like Quebec has done, can impose a cap and trade system. Right? They have most of the constitutional clout to regulate the environment. What the Supreme Court of Canada has said, however, is that there's also room for a federal role, specifically setting a minimum national standard. Okay, and so that's essentially, it's as narrow as that, right? This case has said that it is constitutional, though you won't find it in the written text of the Constitution. It's a constitutional exercise of the federal power over peace, order, and good government for them to impose a national standard to avoid free riders, right? And that's essentially what it comes down to, is that no one province can force other provinces to behave, in an appropriate way, and to hold them to, this idea that there should be a framework for addressing climate change across the country. It's only the federal government that has that power to be the arbiter here and to say, okay, here's the standard we all have to meet if we're going to meet our international obligations. And that's essentially what the Supreme Court of Canada said, is that, okay, that is justifiable, that is constitutional. And so that debate has been resolved now into the future. Short of the Supreme Court of Canada in, I don't know, the year 2035 revisiting this and saying, whoa, that was actually a bad idea in hindsight. This is the nature of the law now. So it is a permanent precedent to be followed.
Cool. So I guess I don't know much about the Maritime Provinces, Manitoba. Obviously we know BC's had their own carbon pricing system, and you talked about Quebec that actually I didn't know too much about. But were those provinces that were silent? I mean, have they had their own kind of system, or were they just kind of neutral on the whole thing?
I'm going to plead a bit of ignorance too. I don't know that much about the Atlantic situation.
Yeah.
What I do know is that New Brunswick changed governments as well. And so while they didn't have time to do their own judicial reference and waste a bunch of taxpayer money on it, they had eventually, I think, intervened in favor of the challenges to the Federal Act.
Oh, okay.
But here's what I'd say at a level of generality. It's that, this is ultimately federal legislation that puts a backstop in for the naughty provinces who refuse to put into place their own particular regime. But it's also an opt-in option for territories and provinces that might just be of the view that, they're too small and it would be too expensive to manage their own comparative regime. And so I think Nunavut and the Yukon and PEI have opted into at least parts of the federal legislation. I think for Yukon and Nunavut, they opted into both aspects because they're just small or territories, small populations. Well, and then I think PEI opted into the industrial part because, they don't have a booming oil and gas industry or anything to worry about. And it's a little easier for them to have a fuel tax or a fuel charge, something to that effect. And so, there is that aspect where, if you're Alberta or you're BC or you're Quebec, there might be all sorts of reasons to create your own regime and to manage your own regime. But it becomes a little bit like the PST, HST, GST debate, right? Where you got to strike a balance between efficiency and just harmonizing with the federal system and basically making the federal arm of government deal with it on your behalf versus reduplicating all that bureaucracy. The costs have to outweigh the benefits, if that makes sense.
Yeah. I'm glad you mentioned the territories, because that was actually going to be my next question, and how it impacted them, especially with like Nunavut when they have so much diesel power generation, and they don't really have any alternative options for power production. I mean, how does that work for them?
Yeah, so here's what I can say is that they are under just the general federal regime. And so that's one aspect is the fuel charge. And then the other aspect is the large industrial emitters. Large industrial output-based pricing system, I think is the correct terminology, if that helps. They don't yet have an oil and gas industry in Nunavut that I'm aware of, although there are offshore oil and gas reserves that the government in Nunavut is at least open to exploring. So they're not quite dealing with the same level of, it's complicated too. I don't know, how complicated do you want me to get this? 'Cause there's also something called devolution where Yukon and Northwest Territories have taken on province-like powers over natural resources. Nunavut is not yet there, but they will soon be at that level where they have most of the jurisdiction over natural resources. Right now, they're primarily regulated by the federal government anyways.
How do territories and provincial jurisdictions work? The differences?
So provincial jurisdictions they're set out in that 1867 Constitution. And so it's a constitutional division of powers. And if something falls clearly under provincial constitutional authority, then the feds have to butt out and vice versa. Right. Okay. And so there's some overlapping and there's blurring of lines. Society's more complex today than it was in 1867. But they have this very powerful constitutional authority that they can informs their negotiating position for federal regimes like this. When it comes to the territories, the default is that they're essentially like municipal governments. There's a federal legislation. There's something called the Nunavut Act, for example, that creates the Nunavut territorial government, and that gives it a bunch of powers that, by coincidence, look a lot like the powers that the provincial governments have under the Constitution. But the federal government could claw those back. So they don't have constitutional protection for it.
Nice.
And devolution it's kind of the next stage between a territory and a full province. And so it will mean full control over natural resources within the territories, short of having a constitutional backing for it. And that would require a constitutional amendment. And no one's really wanted to swat at that hornet's nest for at least my lifetime.
Right. Oh, thanks for the clarification.
No worries.
I'm definitely in favor of Turks and Caicos joining Canada.
There you go. Yeah, once they're ready, then maybe we can reopen constitutional talks.
So I guess aside from how it impacts the fight against climate change, I mean, do you think this decision will have broader impact on federal and provincial relations, especially as we go forward and have to address more global issues?
No, not necessarily. I mean, yeah, it's a hard call. Here's what I'd say is that had it gone the other way, then definitely, right? Had it gone the other direction and the Supreme Court of Canada, a majority had said, no, this is actually something that the federal government can't do, that could have allowed for some unraveling of the case law that's in place. But as it stands right now, generally speaking, even though there's no federal power over the environment, what we do know is that federal statutes like the Species at Risk Act, it's backed by the federal government's power over the criminal law. And so they have an environmental law power to basically create environmental regulatory offenses. And there are a number of statutes that do that. And they also have, this power over at least minimum standards for carbon taxation. And they also have a power over marine pollution. That was based on the last big peace order and good governance environmental law dispute to make it up to the Supreme Court of Canada in the 90s. Mm-hmm. So there's a fairly robust amount of cases now suggesting that the federal government has a big role to play in environmental regulation. And so one thing that's happening right now in Alberta is that the Alberta government has also been challenging federal environmental assessment legislation, and they're hoping for the Alberta Court of Appeal to say that that is constitutionally overreaching by the federal government as well. Mm-hmm. There's a chance that the Alberta Court of Appeal may indeed come to that conclusion, but there is also this possibility for the federal government to take it up to the Supreme Court of Canada if that is the outcome. And this case could strengthen some of this kind of national power doctrine in favor of that challenge. It's a very different piece of legislation. It's not a crystal ball to tell us exactly how that would play out if the case does go to the Supreme Court of Canada, but it is one more kind of, one more case that's gone the federal government's way, building up the authority that they have over environmental protection, if that makes sense.
Huh. Yeah, I mean, that's really fascinating. Anything you want to kind of add to or ask or anything like that, Fred?
I mean, not at the moment. This has been a very educational moment, to say the least.
Yeah. No. So, if you talk about your expertise, you're saying that like you're an expert in federalism. I guess I'm curious about that topic, right? Because it's like, as you say, back in 1867, they weren't so much thinking about, in protections for the environment, right? And obviously, they couldn't have anticipated even at a very globalized world as we're kind of moving towards. And if you think of like, I saw something, I'm not sure if I read it or saw it somewhere not too long ago, but how what we see in the European Union now, where you have this group of countries that kind of have this loose association, really was the United States like 200 years ago. It's just that there was no allowance in their constitution to kind of backpedal, and so they're kind of just stuck with what they got. So I mean, you know, when there's kind of a very rigid structure, or a rigid kind of differentiation between powers between the provinces and the government, I mean, how is that, or the federal government, how is that going to impact us as we're dealing with, globalized issues going
Yeah.
forward? Like.
Yeah, I mean, it's a tense situation. So at the same time that this climate change challenge was going through the courts, there was also a challenge in Quebec to the Federal Species at Risk Act. And the concern there was you have another federal statute that was applying to protect the western chorus frog, so a species at risk that's federally listed, that happened to be in a part of metropolitan Montreal that was stopping some kind of real estate development from going ahead. And the developer had enough financial clout to try and take this through the courts and challenge it. And so we do have this constant possibility or vulnerability to these federalism challenges when the federal government is taking these kinds of actions. But on the flip side, right, this is policy neutral in a sense. And so there are also cases where we've had federal or provincial governments that may not be doing right by the environment. And this federalism has been, to give it a bit of a warfare kind of metaphor here, but it gives ammunition to environmentalists who might want to challenge what the government is doing. So a famous example in BC, you had a bunch of basically advocates against open net pen salmon farming. And what they did is they successfully challenged the provincial jurisdiction over salmon farming. And they said, hey, you know what? Actually, fisheries are in the Constitution a federal power. Why is BC the one that's in charge of and making all this money off of net pen salmon farming? And they won in the court. Now, the federal government just basically delegated its authority back to BC, and they kind of figured it out in a way that had minimum political consequences, because both the federal government and the provincial government were pro-salmon farming at the time. But you do have these vulnerabilities that can go in both directions. And so this is why, from the lawyer's perspective, everyone's excited, and you'll find very few lawyers and law profs who say that this was a waste of time, because, we're all really fascinated by these constitutional issues, but they're politically neutral constitutional issues. It's frustrating when you have a federal government that wants to take meaningful action on environmental protection, right? Because then you've got the possibility of these challenges that might fetter it. But the roles could be reversed. And it could be the situation where you've got a federal government that's doing the opposite, and perhaps using federalism for leverage is a way to push back against that federal overreach that might be contrary to the goal of dealing with greenhouse gases, for instance. So
Yeah.
I don't know if that's helpful or not. It's
Right.
Yeah. No, this is really helpful. Yeah. Thanks so much for coming on and chatting with us about this. I mean, it's such an important issue, and I feel like doing what we do, with regarding energy efficiency and climate, and lowering GHG emissions and everything like that. We're kind of at the epicenter here in Alberta of that kind of fight, right?
Mm-hmm.
So, I really appreciate you coming on and chatting with us about this. Thanks so much.
Yeah, it was my pleasure.
Thanks so much, Ben.
Cool.
Thank you, guys.
Have a good day. Take care.
Yeah, you too.
To learn more about how you can save money and lower your environmental footprint, visit originenergy.ca. Remember, you can always leave us an audio message by visiting anchor.fm/originpoc. We'll definitely include interesting messages in future episodes. Thanks for joining us, and thanks for helping us power brighter communities.